Mr. York, let me just pick up on that with you for a second. So, as I understand the Delaware statute, you must file this under seal. Nobody looks at it except for the judge. And in fact, it's supposed to be filed with the state clerk, and they call them something else there, but there you are. And the case cannot proceed. Whereas I think you're acknowledging in federal court that wouldn't apply, because once a complaint is filed, the case is off and running, and that's a public document, and you have to answer or move within a certain number of days, right?
The affidavit is a public document?
Well, no, the complaint in federal court is a public document, and that's all that's required to get the case up and running, and a defendant has to respond, right? So that there's a delta there, and you are cracking and extracting, as your friend on the other side likes to say, some things from the Delaware rule that you would apply in federal court and other things that you wouldn't. Isn't that fair?
Well, I think that is true of many state statutes and substantive rules laid out in state court decisions. It's never been true of Erie that in order to apply state law in federal court, you have to take every single sentence written by a state Supreme Court and apply that in federal court.
Well, how do we know what the Delaware state legislature would do? I mean, we're creating this Frankenstein of a statute, right? We're taking bits and pieces and adapting it. And I understand your point, but what authority does a federal court have to rewrite Delaware law in that fashion? And, you know, I mean, maybe the affidavit has to be public and discoverable in federal court. And that seems wholly antithetical to the statute. Whatever the purposes were for making it private, there are obviously good and important reasons for keeping it private. And for it to precede the suit and not to allow the suit to get off the ground. Those were all important policy judgments we would just be paving right over in federal court. What do we do about that?
Sure, so let me answer the confidentiality issue first and then the broader question. The confidentiality issue is easy. It's a state law privilege that federal courts have to enforce through Rule 501 of the Rules of Evidence. Sealing is just the mechanism by which you assure.
Would it be discoverable by the other side, though, even if it's sealed?
No, it's not discoverable. It says
it's not discoverable in federal court.
Because it's privileged. Huh? And privilege is a tremendous.
Is it privileged?
Yes, it's privileged. It's tremendously important in medical negligence cases. Doctors face lawsuits all the time.
We know that it is privileged. I understand it's supposed to be filed under seal. Is that a recognized privilege under state law?
Under subsection D of the statute, it is not discoverable. Well, that is privilege.
I understand. Oh, okay. All right. Well, all right. Put that one aside. Take the broader question that we're picking and choosing, and by what authority do federal courts have?
Well,
and I'll be interested to see what Mr. Tutt has to say about the discoverability point.
Sure. One easy place to look is the Delaware Supreme Court, and there is no dispute that if a plaintiff can't obtain an affidavit, even after the 60 days after the fact, a case has to be dismissed. We've cited some cases in the briefing from the Delaware Supreme Court that apply the statute fairly flexibly, giving plaintiffs more time even after the time has expired. But the one thing they do say is that if you want to maintain the cause of action under state law, you have to obtain the affidavit. And this really was part of the reasoning of the Seventh Circuit, and the Third Circuit has held the same thing. The requirement to obtain the affidavit and the ability to enforce that requirement while the suit is pending and certainly before trial are the two key aspects. Both of those aspects can be enforced using existing federal rules without conflicting with any of them. And that's our only point, and that's what the trial court did here. There was no conflict.
Can you